looking at the Supreme Court and what it is doing on national administrative governance in the both political and legal context, and recognizing how closely those two are tied right now, and how much what we're seeing in the actions of the Roberts Court in terms of this commitment to pulling back administrative power is really part and parcel of a conservative legal and political agenda. I'm Gillian Metzger. I'm the Harlan Fistone Professor of Constitutional Law at Columbia Law School, and I'm also one of the faculty co-directors of the Law School Center for Constitutional Government. So the administrative state lots of it is probably really familiar to people. It's the agencies that you interact with every day when you interact with government. It's the post office, but it's also the Environmental Protection Agency. It's the Federal Reserve. It's all the agencies that make up government, but it's not just the agencies. It's also all of the personnel, everybody who provides the capacity to do all the things that the government does, to investigate, to issue regulations, to undertake enforcement actions, to adjudicate, to provide advice. And what I'm focused on in particular is the federal administrative state, so the administrative state that operates in the national government. And it includes not just those individual agencies, some of them are what we might call independent in that they have a little bit more protection from removal from office at the top. Some of them are what we call executive agencies, so like, the Department of State or the Department of Defense. But you also have an apparatus that oversees from the center, from the executive office of the president and Office of Management Budget, for example. And those. So all of that is what I call the administrative state. In terms of thinking about what a conservative judge is or what a liberal judge is, those terms have sort of developed meaning over time that actually has changed if you go back to a traditional understanding of liberal, for example. So traditional understanding of liberal, the sort of individual against the state, that kind of neoclassical liberal would be in some ways more of a conservative today because it would be more anti-regulatory, it would be more opposed to administrative power. Whereas liberal judges today tend to be more supportive of broad national regulatory authority, broad congressional power under the Constitution. They tend to, as a result, be less enamored of protecting private property rights or liberty of contract, more supportive of efforts at the national level to regulate in a wide array of areas. Conservative justices and judges today, on the other hand, tend to really be more resistant to broad national power, to think that the national government was intended to be a government of limited authority, and to support a number of particular rights like the private property rights against taking of your property, or more recently, for example, the Second Amendment rights to protect gun ownership. There are other rights they're opposed to, such as substantive due process, bodily autonomy rights. It's a different constellation of rights and a different view of administrative power, but the basic bottom line would be, in terms of liberal justices or conservative justices on the administrative state, liberal justices tend to support a very broad national administrative state and deference to administrative agencies, whereas conservative justices tend to be much more skeptical and believe in pulling back on regulatory power. One of the things that has been playing out, which underlies my argument that the administrative state is under siege, is that the current Supreme Court under Chief Justice John Roberts has really been trying to pull back on administrative power. And as a result, a number of longstanding decisions that have affirmed administrative power have come into question. So Chevron is one of those. Chevron is actually a decision that goes back to 1984. And it was a decision about how courts should review when an agency interprets the statute that it's charged with implementing. So agencies often enforce very complicated statutes. And the question is, when they do that and they interpret that statute, should a court defer or give particular weight to a reasonable interpretation of the statute by an agency, or should the court deem it its role to, in the first instance, establish exactly what the statute means, and then see if what the agency did fits within that interpretation. It matters a lot because these are, as I mentioned, complicated statutes, and they often are pretty ambiguous. The problem is that figuring out when one is ambiguous or not, judges and others disagree. And one of the effects of deferring to agencies in interpreting a statute is the concern that that gives agencies the ability to determine the metes and bounds of their own authority, because they're the ones interpreting the statute, they're charged with implementing it. If a court then defers to their interpretation, is the argument, well, then it's kind of foxes in the henhouse kind of situation. That's really not the case, because under the Chevron decision, again, the 1984 one, a court was supposed to do two things. It was first supposed to determine whether or not Congress had spoken clearly to the issue at hand. And if Congress spoke clearly by looking at the text and the structure of the statute and the history of the statute, Congress wins, right? This is agencies are creatures of Congress and only have the authority that's been given to them. But if, after doing that investigation of the statute, the court determined that it really was ambiguous and also that the agency's interpretation was reasonable, then what Chevron said is, well, at that point, you should defer because the agency has more expertise, familiarity with the statute, and is also more politically accountable, being in the executive branch, which is more of a politically accountable branch than the courts, which aren't at all. So that was a Chevron decision. It wasn't actually that big a deal at the time it was issued. It was a lot of the kinds of some degree of deference to agency interpretations goes back to the New Deal, to before the New Deal in various forms. But what Chevron came to stand for was this idea of very broad judicial deference to agencies. Again, I don't think that's really full accounting of how courts reviewed agencies' interpretations. Particularly the Supreme Court always did a pretty rigorous review, and there are other courts that did fairly rigorous review as well. One of the advantages of Chevron that people who had studied it over time found, well, two advantages. One was that it actually helps reduce political variance. So you have appeals courts that sit in panels of three. And you know, if you've got a panel of Democratic judges and they're reviewing a Republican regulatory action, they're less likely to support it than they might a Democratic regulatory action. Same thing for a panel of Republican judges reviewing Democratic action. But one of the effects of Chevron was to mute that and to really, in that sense, control for politics, as well as provide more consistency across different courts and over time. So conservatives, however, began to really reject Chevron and react against it, in part because it was seen as giving agencies power, and in part because of an idea that the judicial power and the judicial role is to interpret what a statute says, and that allowing agencies to be able to set the metes and bounds and having courts have to defer to them was an improper relationship between courts and agencies. So this year the Supreme Court overturned the Chevron decision. My article is called 1930s Redux, so you have that right in the title. There are a couple of reasons to focus on the 1930s. One is because the 1930s was a period in which the National Ministry of State really came into its full flowering in the New Deal and post-New Deal period. We'd had it going back before that for sure. There's actually a long history of National Ministry of Governance, but that's when it really took its full flower. That's also the time at which you saw very similar conservative attacks on administrative power at the national level and arguments that it violated separation of powers and exceeded Congress's scope of authority. We had it like in the 1980s with Reagan. There were also attacks on regulation and efforts at national administrative government, but they were more political attacks. They were less constitutional attacks. So you go back to the 1930s to get this same kind of constitutional attack that we've been getting under the Roberts Court since around 2010. So it's very relevant in that sense, and it's also relevant in that one of the things that happened as a result of the Supreme Court's attack on administrative governance in the 1930s was a real legitimacy crisis for the court in the 1930s. And the court packing plan and the supposed switch in time that saved 9 in terms of the Supreme Court changing its tack on national government and national administrative power in response to the sort of mandate for the New Deal government. So that's one very important reason to learn some of the lessons of 1930s today. The importance of looking at the Supreme Court and what it is doing on national administrative governance in the both political and legal context, and recognizing how closely those two are tied right now, and how much what we're seeing in the actions of the Roberts Court in terms of this commitment to pulling back administrative power is really part and parcel of a conservative legal and political agenda.